session today. Uh, Welcome to the Family Support Institute Learning Exploration session on wills, trust, and estate planning, presented by Geoffrey White. My name is Julianne Kadra, and I'm your FSI host for today. I'm a resource parent with FSI and a parent to a 17-year-old son with a heart condition and autism. Before we begin, I would like to acknowledge that I'm meeting with you virtually today from the Coast Salish lands, the unceded territories of the Katzie, Kwantlen, and Semiahmoo First Nation. It's on this land that we live, we learn, and do our work. As a provincial organization, FSI acknowledges that our work spans across all the traditional, ancestral, and unceded Indigenous territories in BC. We respectfully honor all First Nations, Inuit, and Métis people, as well as their ancestors who have lived here and cared for these lands. It's with a deep gratitude that we are able to live, learn, and do our work in the province now known as British Columbia. For those of you who may be new to the Family Support Institute, we are a nonprofit society and a network of trained volunteer resource parents throughout BC. Each of us has a child or a family member living with a disability, diagnosed or not. FSI is unique in Canada as the only grassroots family-to-family organization with such a broad and diverse volunteer base. Our network supports and connects families by sharing experiences, expertise, and guidance. All FSI services and supports are completely free to any family. Like many of you, the lived experiences we carry can be incredibly valuable to those coming behind us, paying it forward, so to speak. If you would like to learn more about the wonderful work that we do at FSI, or if you're interested in becoming a resource parent, please visit our website at www.familysupportbc.com. I'll put the link in the chat along with FSI online guidance. Please take a moment to review them, as they help ensure we maintain a respectful, inclusive, and supportive space for everyone. Please also note that AI recording on transcription tools such as Fireflies or other note-taking bots are not permitted, as they can introduce compromise privacy. And now, without further ado, let me introduce you to our guest speaker for today, Geoffrey White. Geoffrey, please go ahead.
Thanks, Julianne. I'm glad to be here with everyone, and thank you for that introduction and for telling us a little bit about FSI and how it can help out. My background, I'm a lawyer. I've been in practice for about 30 years, and I do mostly wills and estates in my practice. That's what we focus on. And in that area, I work a lot with families who have disabilities and are affected by it. I probably have worked with well over 1,000 families, I would think, by now over those 30 years. And what we're going to talk about tonight is a lot of the issues that those families look at and face, and just some of the basics of what's the important information to know about. And really happy to as well make sure we set aside some time to take some questions from you. And I do already have, I think, on my list here about 8 questions that have already been sent in advance, and I'm going to try to make sure that I come back and talk about those as well. And so I'm just going to lead in. So in terms of me, oh goodness, there's a lot on there. That's just a little bit about my background. And so I do also do sessions like this for lawyers to help them learn how to deal with disabilities. I just actually did a session this afternoon for some lawyers, accountants, trust officers, and financial planners, just talking a little bit about how families approach this area and what some of the strategies are that we use to develop it for them. And I also edit the manual that lawyers use when they're trying to decide how to probate an estate and do those types of things. So let's just jump right into what our agenda is going to be for tonight and the topics that we're going to cover. And as I say, we do have those 8 questions, so I'll try to make sure that I bring them into the discussions as well. So we're going to first talk about disability benefits in British Columbia, how that works, how we as a society organize ourselves to help make sure that people get support. Then we're going to talk about estate and trust planning when we have people with disabilities and how we're going to try to make sure that their eligibility for those benefits are not affected. Second, we're going to talk about one of the really important aspects of that, or third, I should say, which is choosing trustees. So who's going to implement the plan that we're trying to put in place? We're going to talk about other planning tools, so it's not just all about wills and trusts. And then I'm going to leave you with some resources that you can go to follow up from today, and we'll have some questions and answers. Now we are set up from 6:30 to 8:30, so I'm going to do a bit of the presentation material. We'll probably take a little bit of a health break for everyone, just to stretch your legs and maybe get a drink. And then we'll go back into it, and I'll leave probably about 40 minutes for questions. So I'm going to try to just split it up that way, 20 to 30 minutes, a little bit of a break, 20 to 30, and then we'll have our question and answer. So let's talk a little bit about why we need to talk about the estate planning. So in British Columbia, we have a system of supports for people who have a disability. And it's basically the legislature has kind of taken up the community desire that people who face challenges due to a disability should get some supports from our community to be able to participate, and so that we, as the people in the community, can benefit from everyone being involved and having an active role. And so one of the ways we do that is providing something called employment and assistance for persons with disabilities. You might hear it referred to as PWD, that's an acronym that's often used, or provincial disability assistance. It's operated by an arm of the government, one of the ministries. It's called the Ministry of Social Development and Poverty Reduction. So they're charged with implementing the act and carrying out the rules and regulations and policies that are there. And what it does is provide a basic level of income for someone. And so that works out to, right now, it's currently for a single person about $1,400 plus or minus a bit. And that's monthly. And then also, the person would be entitled to certain health benefits. They're not fantastic health benefits, but it does give them something a little bit better than not having that coverage. For example, it's something like $2,000 for dental work over a period of time. But to be able to qualify, there are certain criteria that you have to meet. And so, first of all, you have to be the age of 18 years or older. And then secondly, you have to have a disability, and it has to be a prolonged and severe disability, and it has to affect certain of your daily living activities. And that's usually tested by doctors filling out a report and filing it. But once you've met the medical tests, there's also a financial test. And that's because this is intended to be kind of a supportive last resort that only helps where there's certain financial needs. So the financial test is broken down into two parts. It has an asset test and an income test. And so what you see on the slide here is a bit of a discussion about the asset test. And this is the one that's most affected when we talk about estate planning and inheritances. So the asset test is that a person must have only $100,000 of assets available to them. Now that's actually an interesting number, because when I first started doing this 30 years ago, it was about $3,565 was the number. It was based on what people had for their minimum tax threshold. And so it's quite low. And over the years, it's gradually grown and grown and grown. And so now we're up to the point where it's $100,000. So it's actually quite significant and generous. It also allows someone to own a vehicle, and they can actually own a home that they live in. So there are lots of good assets and good asset base that a person can have to be able to support themselves. But what we find is the $100,000 is still actually quite a small number when we compare it to what an inheritance is. And so when someone is receiving a house from a parent that's being divided among a couple of kids, or investments that are being divided among a couple of kids, it's not unusual for that inheritance to be much larger than the $100,000. And so that would, if we don't do something about it, make them ineligible. So even though they have the same medical condition that they had before and qualified, They don't qualify if their assets are over $100,000 unless we can find a way to protect it or exempt it. And that's what we're going to talk about tonight. So part of that planning is just the general idea that as a parent who is leaving an inheritance, it's a really important idea to have a will. Because if you don't have a will, it creates some really big problems. And you can't do the type of planning that we need to do to protect that eligibility. So as an example, if you don't have a will, then you don't have a way of telling anyone what it is you want to be done. And the province can't allow that to happen. There has to be some rules that get put in place to deal with things that people own when they die. And so we do have those rules. It's under a law called the Wills, Estates and Succession Act, and it's called an intestacy. So an intestacy means you don't have a will. And so those intestacy rules set out all the basic provisions about how that should happen. And it's actually sometimes quite different than what people expect. So, for example, most people think that if you pass away and you have a spouse and you have children, it's going to go to your spouse. And then only if your spouse passes away does it go to the children. Well, that's actually not right. In British Columbia, what happens is a dollar amount, a certain dollar amount goes to the spouse from the estate, but then it's actually split between the spouse and the kids. So, and the dollar amount changes depending on whether you and your spouse have children that are all your children, so a nuclear family, or whether you have different children. So it's a blended family where you or your spouse have children from a different relationship. And so if it's the same children, the nuclear family, your spouse gets the first $300,000, but everything after that is split half and half. If it's a blended family where there are different children in the relationship, it's only $150,000 that goes to the spouse. Then the rest is split half and half. Well, given that most properties in British Columbia, I think the average is somewhere around $800,000 or $900,000, are worth a fair bit, you can see that if you own a house and you pass away and you haven't done a will and your spouse isn't jointly named on the house, you just own it yourself, it's not going to go entirely to your spouse. It's going to get split up. They'll get the first, $100,000 to $300,000, but then the rest of it's going to be split between your spouse and the kids, and that might not be what you intended, particularly if your kids are not in a position to be able to deal with that money or manage it. And so it's a really good idea to have a will that avoids these artificial rules that the province will impose upon you if you don't have them. There are other ramifications. So as we've talked about, receiving that share. So if it was that large estate and there were two children, and let's say it's half of it, so $400,000 gets left over and is divided in two, well, now we've got $200,000 going to a beneficiary who's getting disability assistance, and they're only allowed to have 100. And so that will put them over the threshold, and they could get disqualified from their benefits, even though they've got the exact same medical needs and financial needs that they had before they received the inheritance. So that's someone who's older, an adult, and receiving benefits. It's even more consequential sometimes for younger children who are minors, because one of the things that you can do in your will is appoint a guardian. You can name who comes in and takes over as the parent if you can't do it anymore. But if you haven't done that in your will, then there's no default. It's not clear who should be in charge of the children as a guardian. And it's actually the Ministry of Children and Families that will come in and take over being the parent and decide who gets to be the parent. So it's a government official deciding who's going to parent your children, not you. So really important for any parent of a minor child to have a will to make sure it's clear what's intended. Also, the estate that would go to the child doesn't go to them. It goes to an office called the Public Guardian Trustee, who guards it fairly tightly while they're a minor. But then, as soon as they turn 19, gives them the whole thing without any sort of protections or other things around it. So it's almost the worst of both worlds. They don't have the money as available as you'd like it to be while they're young, but as soon as they turn 19, they get the whole thing without any guidance about how it should be used. So not having a will is not a great idea. You can see that there can be some very serious ramifications. So what do we do with the will when we say, okay, we've got this scenario and we're going to divide up the estate. We're going to create a provision for each of the children. What we can do is create some trusts around the inheritance. So that 200,000 or whatever the dollar amount is that's going to be going to the child that would put them over the $100,000 threshold, we have the opportunity with your will to protect it. And the way we protect it is by wrapping a trust around it. And so what we do is we create a trust that says, um, this inheritance is for my child, let's say it's Bob, and it'll be used for Bob, but Bob won't control it. Somebody else will control it and use it for Bob, a trustee or an executor that I pick that I can put in charge of managing it. And that will help prevent it from affecting Bob and his eligibility. So the trusts achieve certainty. So we know what's going to happen to it. We know that there's some protection. And it can be very effective to allow the person to continue to receive the same supports that they are relying upon from the province, the persons with disability supports, and it will preserve that $1,400 a month that they get, plus their medical benefits. And then the other thing about the trust is depending on what the nature of the disability is for your loved one, they may not be making the best decisions. And so sometimes, regardless of how it affects the disability benefits or entitlements, we just want to make sure that somebody is involved in making decisions with them or for them so that good things happen with the money. Because one of the things that I see is without those protections, when someone receives an inheritance, other people find out about it. And it's not unusual for other people all of a sudden to decide that they're your son or daughter's new best friend, and they want to come in and help them spend that money, and influence them to do things that they probably wouldn't want to do with managing the money. And so having a trust in place prevents that kind of undue influence and helps make sure that the money really is improving their quality of life, not just immediately, but also throughout their lifetime, to make sure that they are well protected. So using your will, you get a chance to set this all up and take some control over your estate to make sure that things happen the way that you intend them to do. So what are some of the things you can do with a will? Well, you can appoint an executor. So this is the person who's going to be in charge of managing your affairs. It's the person that you're going to hand everything over to say, okay, this is all the stuff that I had. Here you go. Make sure that all my bills and taxes get paid. But then, here's what I want you to do with it. And that's what the rest of your will does. So in that process, you could appoint a guardian. That doesn't have to be the same person as the executor. You can pick who would take over for your children. But again, remember, it's only minor children. So you can only appoint a guardian in BC for a child who is under 19. You can't appoint a guardian for someone who is over 19. There's different things that we have to do for that person if we need to create some protections. When you've appointed the executor in your will, as I say, you can give them instructions. So you can tell them how to distribute the estate, what amounts are going to which person or what proportions are going to which person, and you can identify them. And then, as we just talked about on the last slide, if one of those estate inheritances is going to someone who is receiving or will in the future receive disability benefits, we can wrap a trust around it to protect it so that they stay eligible. And totally aside from the disability benefits, if they might benefit from having someone help them make decisions so that they don't get influenced or do bad things with the trust, having a trustee there to be involved also protects them just in that way. So one of the things that sometimes clients come and talk to me about is, they hear about the trusts, but they find it a little bit complicated, and they just want to simplify things. And so one of the ways that sometimes people think about simplifying is to be able to say, I'm going to divide things up. I've got Bob and I've got David, so I've got two children. Bob has the disability. David doesn't. But rather than create equal shares and create a trust and go through all of that, what I'm going to do is just transfer everything over to David, and then I'm going to expect David will be able to just take care of Bob. He loves Bob. They're brothers. They get along really well, and David's just going to have all the money to be able to do that. And so it sounds like an appealing thing to do, but it can create some really devastating problems. So one of those is that in the province of British Columbia, we have a rule that says that an adult child, if they're unhappy with a will, they can challenge it. So that's different than pretty much anywhere else in North America that gives this right to an adult child. And so the law actually says a spouse or a child, if they believe that the will is inadequate, they can bring a challenge to get the will changed or varied. And what's interesting is in British Columbia, whereas other places child has been interpreted to mean minor child, in British Columbia, it includes adult children. So adult children have this ability. And so there's always this risk then that Bob would challenge the will. But a lot of clients say, oh, but Bob would never do that. He loves David. He knows David would take care of him. He would be okay with it. But the problem with that is that if Bob has any sort of difficulties in decision making because of the nature of his disability, then Bob isn't the only one who makes that decision. The public guardian and trustee gets a notice on behalf of Bob. I'm just going to check to see, that he is entitled to a share of the estate but hasn't received it. So when the will gets processed, you actually have to send a notice to the public guardian trustee, that's this government office, on behalf of Bob, and they review it all and say, well, did Bob get an equal share? And if he didn't, they will actually bring the legal claim on behalf of Bob to change the will, to force a share to be set up for him. And so now you've got this terrible situation where you've got litigation happening and it's expensive and the government is involved and controlling it. And it actually pits Bob and David potentially against each other. And so it's very difficult. So doing that idea of trying to keep it simple by simply not setting something aside for the disabled child, it just doesn't work in British Columbia, and would just create this litigation that would happen over doing it. So really the best way to do it is to set up the equal shares and create a trust. And in fact, what we see happening is if there are equal shares and there's a trust, the government will probably say, okay, that's fine. You've done what's within the range of reasonable. But if they were to bring the challenge, it wouldn't be unusual for the government to say, well, Bob, because of his disability, has higher needs than David. So if I'm going to bring a claim, I'm not going to just stop at asking for an equal claim. I'm going to claim for Bob a larger share. So Bob should get even more to take care of his needs. And so it can, create this really difficult dynamic between the two of them. So the best way to avoid running into those problems is just to create a goodwill that has a fair division between the children, and then we wrap this trust around it to make sure that it keeps Bob or the disabled child eligible. And so how does this trust work? So I keep saying that we're going to take this trust and kind of wrap the benefit or the trust around it, around the inheritance, and then that makes it protected from the ministry. So what happens is we call it a discretionary trust, and we're going to get into the details about that. But basically, because of the way it's structured, it's not treated as an asset. So if Bob had an inheritance, but it's in the trust, it actually never goes within Bob's control. The trust controls it. So when Bob tells the ministry, here's what my assets are, he can say, well, there this trust is, but I don't control those assets. Somebody else does. And so it's a zero value to me. When we add up, my $100,000, this counts as zero. So it's not going to make me ineligible. And so it's a really great way to create that protection. Now, the other part is, and we'll talk about this, there's a way to get money out of the trust during Bob's lifetime that will allow it to pay for things that will improve his life and improve his conditions, again, without affecting his disability benefits. And of course, as we discussed before, by having someone else involved in that trust, if the person with disabilities was vulnerable to anyone trying to take advantage of them or influencing them, that'll be much harder for anyone to do because now the trustee is there to second guess and to manage things and make sure that they don't get taken advantage of. So what is this magic trust that we use? How does it work and what's it all about? Well, the legal terms, the legal way to define it is it's a relationship between a person called the settlor who has property. They give that property to another person who is called the trustee. That's the owner. They will control the assets. They get to decide what to do with it according to the rules that the settlor sets. And they use it, though, not for their benefit, for the benefit of a beneficiary, another person. So it's this kind of triangular relationship. So one way I've kind of described this to folks, to put it into concrete terms, is if I took my children to the movies, and I have my son and my daughter, and I take them to the movies and I buy all the candies, and I buy, a big bag of M&Ms for my son. And we go to the movie theaters and we sit down, and I realize, oh goodness, I have to go to the washroom before the movie starts. So I'm going to go do that, and I'm going to leave the kids there. And I've got this bag of M&Ms that are for my son. Well, I know if I leave the bag of M&Ms with him, they're probably going to be gone before I even get back. And that's not going to be a good thing for him or the M&Ms. So what I do is I take the M&Ms and I give them to my daughter, and I say, okay, these are not your M&Ms. These are John's M&Ms, my son, and you can't eat them. You have to use them for him. And so while I'm away, you hold on to them, but they get used for him. And so what I've done there is I've created a trust. So the asset is the M&Ms. I'm the settlor because I'm the one who had the M&Ms. I've given them to my daughter. She's the trustee because now she controls the M&Ms and gets to decide how to use them, but they're not for her, they're for my son, and he's the beneficiary now of the trust. And so she gets to decide how to use those M&Ms for my son. So we've just created a little trust there. So there are different types of trusts. What I've just described is what people would call an inter vivos trust or a living trust. That's because I'm alive when I gave the M&Ms to my daughter to be able to use them. So we call that an inter vivos or a living trust. There's another type of trust that's called a testamentary trust, and that's the one that is more often used when we're talking about inheritances because that takes effect in a will. So a testamentary trust is where the person who put the asset in has died, and it's their will that is creating the trust. So testamentary means upon death, and so that's a difference. And there's some tax differences between an inter vivos trust and a testamentary trust. We don't need to get into too much details here about that, but these are terms that you will hear. Now, both of those types of trusts can be effective for protecting from the inheritances. I would say that 95% of my clients probably just wait and do the trust through their will in a testamentary trust when they don't need the money anymore. But just so you know, it is possible to set up the trust even now while you're alive. It's just you have to be careful about what the tax treatment is for doing that. And each of those trusts are treated like separate taxpayers. They do file their own tax returns for whatever they earn while they're in place. So here's where we get into distinguishing a little bit about the different types of trusts. So you may have heard of a non-discretionary trust or a discretionary trust. So I'm going to just give you a quick example of how that works with my M&Ms as to discretionary and non-discretionary. And then on the next slides, we'll talk about how it matters within the disability program in PWD. So if I gave the M&Ms to my daughter and I said to her, okay, every 60 seconds, you have to give one M&M to my son, to John. You don't have a choice about it. You can't decide to not give it to him. You have to give it to him. At the same time, he can't tell you to give him two. He can only demand one, but he has that right to demand it. Well, what I've created there is called a non-discretionary trust because I haven't left it up to her to decide what to do. I've told her these are the rules, you must follow those rules. And that's important because for my son, he now has an entitlement. He could actually go to court and force her to give him one M&M every 60 seconds. And if she doesn't do it, she's done it wrong. So he has something of value there. So he can't anymore call that zero value. It's worth something. It's worth one M&M every 60 seconds. And so that's called a non-discretionary trust because the beneficiary does have some value in it. Now, if instead I said to my daughter, here's the M&Ms, you get to decide. You can give him no M&Ms. You can give him one M&M every once in a while. You can give him all the M&Ms. It's entirely up to you. Use your discretion to decide. Well, now it is fully up to her, but my son doesn't have any legal rights to enforce that. So she's allowed to say, nope, I've decided not to give you any M&Ms today. And so he doesn't have any value in that because he can't force the M&Ms to come to him. So that's what we call a discretionary trust. So really, when you want to distinguish, is this a non-discretionary trust or a discretionary trust, you have to ask the question, well, what are the rules for the trustee and what is the beneficiary entitled to force the trustee to do? If the beneficiary can enforce something, well, now you've got a non-discretionary trust. But if it's up to the trustee and the beneficiary can't enforce it, then it's now a discretionary trust. And that matters, as you'll see in a second, when we talk about how the ministry treats those trusts as to whether they're exempt or not. So first, the non-discretionary trust. So as I described, the trustee doesn't have total control. There are rules, and the beneficiary can require those rules to be enforced. They are an exempt asset. So if we put money into a non-discretionary trust for someone who's receiving PWD, it is exempt, but there's a limit. And that limit is $200,000. So over the lifetime of the person in the trust, only $200,000 can be put into it. You can't put $300,000 in or it's not exempt anymore. So you do have that limit. The other part of, and that's because the beneficiary has some entitlement to get some of those assets. You can extend that $200,000 limit, but you need to get special permission from the ministry, and you have to demonstrate to them why that extra money is necessary to be spent on the beneficiary over their lifetime. So it's possible to do, but it's a little bit awkward. So the advantage of it is the beneficiary has some entitlement to get things, but the disadvantage is that it's quite limited by this $200,000 amount. Now, I should clarify, it's very carefully defined to be just what the contributions are. So you could put in 200,000, or you could put in, say, let's say $190,000, and it could grow to be worth $250,000. You can still put in another 10 because you've only put in 190. So it's not what the value is, it's how much you've put into the trust. That's how it's determined. But at the same time, if you put 190 in and then you put in another 10, but then you took out 50, you can't go back and put another 50 in. You've already put your 200 in. You can't go over it. So you do have to be careful about the non-discretionary trust and what the rule is about how much money you can put in. When we have smaller inheritances, or maybe some that are unexpected, the person gets some money from somewhere they weren't expecting and it's under $200,000, these non-discretionary trusts can be useful. But most of the time we're using this other type of trust, which is the discretionary trust. You also will hear of this referred to as a Henson trust. But the discretionary trust, remember now, that's where my daughter has full control over the M&Ms. Doesn't have to give anything to my son unless she decides to, and has the full decision-making power to decide how much and when. So that means that my son can't enforce it, which means it has a zero value to him. So that means there is no limit on how much money can go into that discretionary trust because it has no value. Whether it's got $100,000 in it or $1 million in it, it still has no value to my son because he doesn't get anything until my daughter decides to pay it out to him. And so that's the type of trust that we're most often using because it's the most flexible. Doesn't matter what the inheritance is going to be, as long as we've wrapped it in this discretionary trust by appointing someone in charge of it, we've created this protection. Now, the term Henson comes from a family that did this. It was back in Ontario in the 1980s, and they set up a trust, and they had an inheritance, and they set up this trust that had this, this discretionary nature to it. And the government then in Ontario at the time took them to court and said, there's this trust. The person passed away, it created the trust, and now that beneficiary is receiving, they call it Ontario Disability Assistance. And so we don't want them to get the disability assistance anymore because they've got this trust. And the court said, no, they don't. The trust is there, but they don't control it. It's zero value to them, so they still meet your asset test. They haven't exceeded assets that they have because they really don't have the trust. They don't get anything from it until the trustee decides to give it to them. So that was the name of the family that had that case. And so after that, you'll hear people then referring to it as a Henson trust interchangeably with this idea of being a discretionary trust. So that's the type of trust that we're most often using for parents who are creating an inheritance. So again, my example of Bob and David, we would set up the will. It would say if we pass away before each other as spouses, and now we're dividing up, the surviving spouse is dividing up their estate, we're going to divide it equally between Bob and David. We would do that, but with Bob's, we would put this trust in place and say, don't pay it to Bob directly, hold it according to the terms of this trust. Here's who's going to be the trustee, and they have full discretion to decide how much to give to Bob over his lifetime, but we want them to be generous. We want you to help him out, but Bob himself has no entitlement to it, and that allows Bob to continue to say, zero value for the asset test. I still qualify to get my PWD, even though I've got this trust. So when we're setting up the trust, there's some things that we have to be careful about. And really, this is the job of the lawyer who's working with you to make sure that it qualifies as a proper discretionary trust. But there are things that you might want to think about when you're working with the lawyer to do it. So the first part is there always has to be an ultimate beneficiary. I can't do a trust that says, hey, this discretionary trust is for Bob, period. If I do that, the law allows Bob to collapse the trust. So I always have to ask and answer the question, what happens if Bob passes away? Where should this money go if it's left over? And so that may be to children of Bob, it may be to David, it may be to a charity, it may be to other beneficiaries, but I always have to have somebody there as the backup. And by having that backup, that means that the law won't say, well, this is just David or Bob's money because Bob's the only beneficiary. The law now has to say, well, this isn't necessarily Bob's money because there are potentially other beneficiaries who could get it at the end of the day. So that's the first part. You have to have kind of an ultimate beneficiary. The second part, though, is even though we've got this ultimate beneficiary, we still want it all to be used for Bob, or as much as we can to take care of him generously. And so you have to do something called excusing the trustee from the even hand principle. So the even hand principle means that trustees are always supposed to be neutral. Whenever they have a couple of beneficiaries, they're always supposed to be treating them fairly. And that would mean in this type of trust, well, we don't use it all for Bob because we always have to make sure that there's some money left over for these ultimate beneficiaries. Well, in this case, we aren't worried about those ultimate beneficiaries. We're more worried about taking care of Bob. So we have to put in a clause that says, trustee, your primary job is to take care of Bob. So you use as much of this money as you think you need to for Bob. We'll leave that up to you. You shouldn't feel like you're obligated to try to leave money left over for anybody else unless you think that's an important thing to do. But really, you can spend it all on Bob if you have to. So that's the second point. We have to make sure that the trustee has that ability. And then the third part is you have to be wary about collapsing the trust. And so that's just a legal thing that can happen again if the beneficiary has control. So if they can change the trust or become the trustee that means the trust is collapsible and it's not discretionary anymore. And so again, your lawyer, when they're drafting it, has to be careful to make sure that it fits all these criteria. Because if it can be collapsed, now the ministry is going to say, well, that's not a discretionary trust anymore. That's a non-discretionary trust, and now you're limited to this $200,000. And so you have to make sure when you're designing it to be a discretionary trust that you're actually successful, and you do meet the criteria to be able to do that. So what we've talked about so far is if I've got an inheritance and I give it to the beneficiary and it's more than $100,000, it's going to be a problem because they'll be past that $100,000 they're allowed to have. They won't meet the asset test anymore. And what we've described is if I wrap it in a trust, that's okay. It's exempt from the asset test now. So I've protected it from that. But remember back at the beginning when I told you about the tests, the financial tests for disability, there's actually two of them. It's not just the financial test, it's also an income test. And so the way that income test works is whenever the person receives any sort of value or money during a month when they're receiving disability benefits, they have to report that to the government. And it's presumed to be what is called unearned income. And any dollar of unearned income gets deducted against the next month's dollar of benefits. So an example of that is if you had a GIC and you earned $200 of interest on the GIC, you would have to report that $200. And then the next month, instead of getting $1,400, you would get $1,200 because that's what's called unearned income. So if all we do is create a trust, but we have no way to actually use any of the trust money to help the person, if it's all unearned income, we haven't really solved the problem. We've protected the asset issue, but we haven't protected the income test. So the other thing that the trust has to do, fortunately, is it can make distributions during each month to the beneficiary. And as long as it does them for what are called permitted disability related costs, those are now exempt income. So they aren't unearned income. They don't count against the income each month. And you can now pay for things without ruining their ability to continue to get the $1,400 a month. And so there's some very specific things in the rules about what you can pay for. And then there's one really nice general category. So the specific things are caregiver services, education or training, home renovations, home maintenance, medical aids. Those are all very specific things. You can pay as much as you want to for those, and it won't affect the person's income test. But the other nice category is promoting the person's independence. And so it's actually a very generous and flexible way to use money to help the person. So it's interesting. The legislation itself says promoting the person's independence in the opinion of the minister, which is the government office. And so you would think, oh no, they're going to make it really tight and make it hard to do things that promote the independence. But it's actually the exact opposite. The government has been very, very generous in how they interpret promoting independence. And so we see clients paying for things like clothes and food and rental assistance, cell phones, cars, travel to visit family, travel to just go to Disneyland, going to concerts, going to classes, doing all kinds of different things. So as long as you can show that the money being paid out of the trust has gone to pay for a specific purpose that is promoting the person's independence, then all of those payments are exempt and they are not unearned income and they won't affect the benefits. So really what we want to do is have a trust that protects the capital of the inheritance and use the trust in a way that creates these disability related costs so we can improve the life of the person with the disability by buying them and spending on extra things for them that they would not otherwise have been able to afford. And they'll still be able to get the $1,400 a month, which they can use for whatever purposes they want. Those aren't limited when they're doing it. So that's how the trust solves both problems. It solves the asset eligibility problem and it solves the income eligibility problem. And so again, this slide is describing again what I've just described, but using the specific terms. So earned income versus unearned income. So unearned income is bad. That's what you get deducted dollar for dollar against. The disability related costs are useful because we can pay that out. The other thing that someone could do, by the way, is earned income. So earned income is only being paid to do a job. So you have to be careful about that because sometimes people would say, well, I earned the income on my GIC. That's earned interest. It's not. Under disability rules, the only thing that counts as earned income is you did some work and someone paid you for doing that work. But the good news is if you have the ability to do that and you do earn some income, you can earn up to $17,000 in a year before it affects your benefits. So that's a pretty good opportunity for someone that does have some capacity to go and do some earning. So really, there is unearned income, which is bad. It gets deducted dollar for dollar. There's earned income up to $17,000. And if you have a trust, there's also disability-related costs, which are okay. They're exempt. They can help improve the person's lifetime. So that's how we use the trusts without negatively impacting the PWD benefits. So when we create the trust, it's always important to report that properly. If you've got someone who's receiving PWD now, you know there's a monthly report that has to get filled out and sent in, and you have to report money that you've received. So when we receive an inheritance, we have to report that the inheritance has been received, and we also have to report about the trust to confirm to the ministry that yes, it's put into a trust and it's the right type of trust, and they have to review it and confirm that to make sure it is in fact an exempt asset. So that's what we help clients do once a will takes effect and is in place. Now, what can the trust hold? It can hold an investment account, it can hold a bank account, but it could actually hold other things. So it could hold a property, it could hold a home. And so we could have a trust that owns a residence that the beneficiary lives in. That's okay, we can do that. Other things like life insurance, RSPs, RIFs, and those things can also be directed to go into the trust to create that protection so that the person doesn't go over the $100,000. I've got a minute here, so I'm just going to tell you another little tip about the RSPs and the RIFs. So generally, when you have a RIF or an RSP, you put the money in and you get a tax credit and it grows tax-free. But when you start to pull the money out, you pay tax on it. And in fact, when you die, you're treated as if the whole thing gets taxed. Now, there is an exception for that. If you have a spouse and you name them as the successor or the beneficiary, it can go over to their RSP or RIF without being taxed, and it only gets taxed when they pull it out. But at the end of the day, when the spouse passes away, so the last surviving spouse passes away, and it's going to be now divided among the kids, usually what happens is that gets fully taxed. So if you had, for example, an RSP or a RIF of $400,000 or $500,000, it's like somebody wrote a paycheck to you, to your estate, for that much money, and so you get all the taxes deducted off of that. So on $500,000, that could easily be $200,000, $250,000 of tax that the government collects back. And so there's only half of it left. So the good news is, if you've got someone in your life who has a disability and it is a disability that affects their mental decision making or the ability to cognitive impairment, and they have the disability tax credit and you set up the trust in your will right, we actually have another rollover. We can take that $500,000 and instead of having it taxed in your estate, we can roll it over into the trust for the beneficiary. And now it doesn't pay the tax. It only pays the tax when they pull it out, and they only pay it at the rate that their taxes are. So if they've got very low income or no income over their lifetime, we might never pay any tax on that money. So we've taken an asset that was $500,000 that would have had, a $200,000 and $250,000 tax bill on it, and instead we can take the whole $500,000, set it aside, and use it for our child that has the disability and maybe pay no tax on it. So instead of having only $250,000 left to our estate, we've got 500,000 that we can actually use. So it's a really great way to take advantage of the tax treatment and how it interacts with these types of trusts. So some other issues to consider when we're setting up the trust. So what's the best type of trust? Should we do a non-discretionary? Should we do a discretionary? In most cases, it's probably going to be the discretionary trust. How much does it cost to set up the trust? How much does it cost to continue to operate the trust? Are there other things that we can do? So should we just buy a house instead? Or should we do something called a registered disability savings plan? That's another way that you can shelter some money. What are the personal circumstances of the beneficiary? So are they able to make decisions? Do they want to be involved in managing the trust with a co-trustee? Are they married? Do they have children? So when we're setting up a trust, do we need to think about that trust helping not just them, but also their children who, might be your grandchildren? What's their life expectancy? Are we expecting, a full life expectancy? So a long time, we have to make sure that this trust lasts for a long period of time. Or is it possible that they have a reduced life expectancy? So we need to think about how this money is going to be best used for them more quickly. What are their existing assets? I keep talking about the $100,000. Well, if they've already got $40,000 in the bank account, really they can only get another 60 because that, when combined, will put them over 100. And then the last part is the choice of the trustee. So who's going to make decisions and who's going to be in charge of getting this all done for you? So what I'm going to do is I'm just going to pause there. I'm going to take, it's about 7:20 by my watch. I'm just going to take about 5 minutes for everyone to just stretch your legs, get a drink, have a bathroom break. And then I'll come back in about 5 minutes and we'll spend some time talking about choosing your trustee. And then we'll open it up for some of the questions. All right, so I'll be back and I'm just going to shut my camera down if I can. Here I go. And video, and then I'll be back in about 5 minutes. I'll see you then. Okay, so I'm going to just give us about 20 seconds just for everyone to get themselves back organized and together, and then we can get started again. We'll be talking about the trustees and the selection of the trustees, and then we'll go into the questions. Right. So that gives just over 5 minutes on my watch, so I will get started again. So what I'm going to do now is just take this slide and go to that last bulleted point and just expand it out a little bit and talk about the trustees and what we might want to do and what we might want to think about when we're trying to pick a trustee. So a couple of things that you want to take care of in thinking about are, what's the length of this trust going to be? So how old is the beneficiary and how long is this trust going to last? So we've got a minor who is a beneficiary. It's possible that trust could be, decades long. And so we want to really think about who's got that capacity to fill that role over that long period of time. As noted on the slide, there are some tax considerations. So there is something called the 21-year rule. And what happens is every 21 years, a trust is treated as if it's sold everything that it has, and it needs to do a little bit of tax planning. So again, if you're going past those 21 years, you want to make sure you've got someone that's aware of that and going to be around to be able to think about it. So a lot of clients sometimes pick, brothers or sisters or contemporaries, and that's okay for a while. But we need to think about if we've picked them to be the trustee of their niece or nephew, it's likely that we'll need to think of a backup to them at some point because they're that much older. And that's where the age of the trustee comes in, that how long are they going to be around and be available? Another question is how many trustees should you pick? My view is you should have at least one trustee and at least one backup trustee. So you need at least two people who are able to step in and fulfill that role. Sometimes it's nice to have multiple trustees just because they can balance each other off, but you'd want to make sure that they have a really good working relationships. And then the other part is, how well does that trustee know you and know your circumstances? And really, how well do they know what your hopes and dreams are for your loved ones so that they can make sure that they're operating the trust in the way that you would expect it to be done? Some other issues, do you want the ability to remove them and replace them or to give that to someone else? So if this is a trust that takes a place through your will and you've passed away, maybe you want some other family member to be like a monitor to watch and see what's happening. And if they have to intervene, possibly they could come in and take the trustee off and put a new trustee on if it's not going well. Does the trustee understand some of the things that we've talked about with the Employment and Assistance for Persons with Disability Act or the regulations? And so do they know about the asset tests and the income tests and what the money can be used for properly to keep it exempt? It's important to think about where the trustee lives. So anybody that's within Canada is probably okay to be the trustee. You can be outside of the province of British Columbia, but if they're not really accessible, if they live in Halifax, for example, that's a pretty big geographic distance and time shift, and that may be that they would be difficult for them to do their job. However, if they live outside Canada, now it gets really complicated, and there's a lot of tax rules that kick in, and it's generally not a good idea at all to have someone who does not live in Canada trying to act as the trustee of a trust. The size and the complexity of the trust is also a factor. So, if we're talking about just investment accounts of a couple $100,000, that's relatively straightforward. But if you've got a company or you've got, a larger estate or complicated investments, those things all mean that you want a trustee who's got some experience dealing with those. And then the other part is the conflict of interest. And so this is where what most people kind of first think of as possible trustees ends up running into a bit of a roadblock. And that is, it's not unusual for people to think of family or friends to do it. And that sometimes can create some unintended consequences. So my example, where I named my daughter to be the trustee for the M&Ms for my son, is probably not a great example. Because you can imagine my son is not going to be excited about the fact that his sister gets to tell him what to do with the M&Ms, and that just creates lots of potential conflicts. If I could, I would actually probably be much better having some neutral person involved in dealing with it, and then they can just be siblings. They don't have to worry about conflicts over the M&Ms and the trust, and the other person can be neutral about doing that. One quick example of that is when we name your trust. So if I'm taking Bob and David as my example, and I name the trust for Bob, it's going to say, take care of Bob while he's alive. But if Bob dies, then give it to Bob's kids. But if Bob doesn't have any kids, then give it to David. Well, that creates a bit of a conflict potentially, because now every time that David decides that a particular investment or expense is not a good one to make and the money should stay in the trust, there's always this question that Bob might ask of, well, did you make that decision because you thought it was the right decision? Or did you make that decision because you want to keep money in the trust because when I die, if I don't have any kids, it's all going to you. And so even though between the siblings, they might never really actually be motivated by that, there's always this question of maybe they are. It just puts them in an inherent potential conflict of interest. And so that's one of the reasons why a number of our clients, I would say up to 60% now, are more thinking about neutral trustees or corporate trustees who understand all the complexity of the disability issues and also don't have any of the baggage of being a family member. And you don't put at jeopardy your family relationships just for the purposes of managing the trust. And as I said before, once you've picked your trustee and set things up, that's all really good to do, but we don't want to stop just with trusts. There are other things that can be done. So remember, we can go up to $100,000 of assets. That is fairly significant. We can have a residence or a vehicle. There can be gifting to deal with funds. There's the Registered Disability Savings Plan. That's not really part of the scope of today's webinar, but it's a really great savings tool to be able to put up to $200,000 into an investment that grows and gets matching governments. It's like a pension plan, and it is an exempt asset. And then I did talk a little bit about the RSPs and the RIF rollovers, so that you can get what would have been taxed in your estate down into the hands of your beneficiary with a disability without having to pay the tax in the estate level. You only just deal with the tax as they pull things out. So good planning ensures that we think about trusts, but we do think about all of these things. So not just the trusts, but also all these aspects, so that we're not missing anything, and we don't just assume that it's always a trust that we have to have. So it helps make it work very well. And so then the other thing to keep in mind is who's going to help you do all these things. And so it is a lawyer. Only lawyers are authorized to be able to draft and make trusts. And so, but when you're looking at the lawyer, you want to be careful to make sure that it's the right pick. And so you want someone that, of course, understands making a will and dealing with trusts, but you also want to make sure that it's someone who understands disabilities. So it's very important, as you can see, even just talking about something like this rollover of the RIF and the RSP to the estate, from the estate to the trust to be able to avoid the taxes. You want to make sure the lawyer you're dealing with understands that. And so that would be a good sample question that you could ask them about to make sure that they're going to be the right fit. You could imagine if you had a $500,000 RSP or RIF and the person you are working with didn't understand how that worked, and didn't set you up to be able to take advantage of it, that could actually cost your estate $250,000 of taxes. So it's important to make sure that you're getting the right person with the right experience and the right advice. So just before we get into the questions, some final last words of advice. When you're preparing to do this, gather up the information, consider what the future possibilities are for you and your family and your loved one. Think about your trustees and who would be able to act, and be prepared to discuss that with the lawyer. Part of our job is to help you select the right trustees, and then retain a lawyer that has the experience of dealing with these issues and can answer those questions for you and give you a good plan to be able to get it done. And then finally, ask questions. Come to sessions like this, talk to your friends what their experience has been, and get into doing those things. So those are the resources, but before I'll just leave that there for you while we get into the Q&A part of it. I see there's a number of questions that have come in. And so just to look at these, there's the ministry booklet about disability assistance and trust. That's quite helpful to look at. There is Autism BC and Family Support Institute, of course. And there's also Plan that has information. And then I've just given you my website there in case you wanted to get a hold of us and contact us. So I think that brings me to the end of what I wanted to tell you about tonight. And so now I'm most interested in hearing about what your questions are. And so I think what I will do is just, I've pulled up the Q&A here. I think it makes sense probably for me to just work my way through that. And we'll go from there. So the first question that I see is, can you have both kinds of trusts in place for the same beneficiary? So what I think you mean there is, could I have a non-discretionary trust that the beneficiary has some entitlement to up to the $200,000? And then can I have a second discretionary trust with an unlimited amount, but which they don't control? And the answer is yes. You can have both trusts. you would be paying for two tax returns because they would be two separate trusts. They would have to do each their own tax return each year. So you'd want to make sure that it's worthwhile to do that. But in some cases it is, particularly for the autonomy of the beneficiary so that they know that they can control and manage money on their own. So the quick answer to that is yes, that is possible to do. Um, and so I'll just continue rolling on here to questions. And Julianne, please feel free to jump in and let me know if there's any other format or other questions that we should do. So the next question I have is, if we set up a Henson Trust for our daughter, can multiple people leave money to her in their wills and have it put into the same trust? So that's an interesting question. So yes, technically it is possible to do that, but there are two potential difficulties. So the first is to be one of the special trusts that we talk about, the Qualified Disability Trust or the Lifetime Benefit Trust. It has to meet special rules, and one of those rules is who creates it, a parent or otherwise. And so if other people are putting money into that trust, you might actually taint it. It might lose its eligibility for those special tax rules. Now, if you're not worried about the special tax rules in your situation, and we can always help you determine whether they're important or not, then having people put money into the trust might not be too big of a deal. So I would say that's a really situational specific question that we'd have to look at on a case-by-case basis to determine whether it can have contributions from other folks. Do we have any so the next question, do you have any recommendations about lawyers who may be able to deal with drafting disability will? Are there any resources to help with this, paying to have a will like this done? So in terms of the lawyers, I will let Julianne just mention if there is anybody from from FSI as to whether they have a referral. I can let you know that Plan, which is here on their website, www.plan.ca. I do happen to know that they have a referral list, if only because I'm on it, but there are other lawyers as well. And so those would be two sources to go through to check. In terms of are there any resources to help pay for it? Unfortunately, I'm not aware of any resources. So I don't know of anyone that has a grant or a subsidy or anything like that to do that. That would be a great thing to have, but unfortunately, I don't think there is any. And so the next question is, could a disabled loved one have a TFSA that can be exempted? So yeah, the short answer to that is if a tax-free savings account is set up by the institution as a trust, and most of them are, so the institution itself, the legal structure through which it creates TFSAs for its clients, for all of its clients, is a trust. Then that trust document from the financial institution can often be used to qualify it as a non-discretionary trust, up to the $200,000. So there's a special process that we have to go through to make sure that it fits with those qualifications. But it's nice because it's not quite as expensive as setting up your own trust. It still has some cost to it. But the other advantage is you don't have to do a tax return for a TFSA every year. Whereas if you've set up a trust, you do have to do a tax return for it every year. So that can save you quite a bit of money in annual costs. When you do that, though, you have to remember you have to follow all the TFSA rules that apply to a regular TFSA. You also have to follow all the PWD rules about a non-discretionary trust to make sure that you're staying on side. So it's something that we carefully guide our clients through, but it is something that we've done to help get an informal trust that helps keep smaller dollar amounts exempt. I say smaller dollar amounts because the most you can put into a TFSA right now is about $102,000. So in terms of the costs, so on that TFSA, what if the TFSA is existing before you do the trust? So that the TFSA itself is the trust. So you don't actually create a new trust. It's just we go and get the documentation from the financial institution, which itself is a TFSA. So it's not two separate things. The TFSA is itself the trust. Another question is just how much does a will cost? How much does it cost to set up a trust fund? So what I'll do is I'll tell you about my costs. Other lawyers may charge different amounts. And so you just have to kind of check. And some lawyers do it on an hourly basis. So they have an hourly rate and it just depends on how much time they put into it. I don't do that. I do fixed costs. So once I've talked to a client, if I know what they need to get done, I'll give them a quote, and then we all know what the cost is going to be, and they can make the decision about the investment before they do it. So just to give you an idea, a simple basic will is usually about $1,000. If we're doing it for a couple, the second one is 500. So it's about $1,500 for basic wills. But what we're talking about tonight is not basic wills. We're doing a lot more than that. We're creating an entire trust and putting it into the will and making it have all these different advantages. So that's actually quite expensive. Doing a trust for someone who's alive and creating the trust right away can be as much as $7,500. When we do it in a will, we can usually cut that down by a little bit more than half, and it usually is around $3,500. And so what we're looking at is, is that worthwhile to do? Because there's RSPs or RIFs that we can save all those taxes on. So if you're saving $250,000 of tax by setting it up, it really makes sense to be able to do those things. So it's really important to, just check and see what makes sense to do in your circumstances. So in terms of the next question, is it necessary or beneficial to deal with a local lawyer, or is it easy enough to work with a lawyer out of my home city? Well, there's always, I think, some advantages to having somebody that you can sit down and talk with. But what I can tell you about my practice is that we deal with clients throughout all of BC. So from Smithers to Cranbrook to Victoria and Haida Gwaii, all over the place, Vancouver as well. And we do that because we are able to communicate this way with Zoom and have meetings and then make arrangements for how the person gets the documents signed. And so we do have a lot of contact with clients that are outside of where our offices are, which currently I have offices in both Vancouver and Kelowna. But I think it's important for you to find who you're comfortable with and just make sure that it's a good fit for you. The next question is wondering about the costs for corporate trustees. So this is actually a really good question because as you heard in the presentation, I was telling you that more and more clients are leaning towards the corporate trustees. So the first thing I'll say about the cost, and this is kind of surprising, it's actually no different than the cost that we would be recommending you pay to a family friend or even a family member to do it. Everybody's governed by the same rules. We have a law in British Columbia called the Trustee Act, and there's a section in that law that sets out the rules about how trustee fees get charged. And those rules apply whether you're a royal trust or whether you're a brother or a family member or anybody else. And so basically what the rules say is it can be up to, there's two fees. There's the fee for dealing with the estate. That's the executor's fee, and it's a one-time fee in the first year of the estate, and it's larger because there's a lot of work to do. And then there's an ongoing trustee fee for each of the years after that when you're managing the trust for the person. So the executor's fee can be up to 5% of an estate. If the estate is worth more than 500,000 to $1,000,000, that gets scaled down quite a bit. And so it's mostly going to be in the 3 to 3.5% range. If the estate is quite large, over 5 and 10 million, it gets even lower than that. So it's scaled. And again, that's the same fee that I would tell you to pay to your family member or a company. And then the annual fee tends to be in the range of between 0.5% and 1%, depending on what's being done, and that's applied each year. So that's kind of a typical trustee fee. So the next question is, do you review a will that is currently in place? Not sure if it's sufficient based on what I've heard. Lawyers passed away, don't have a successor. Yeah, so we always, in all of our meetings, we always want to know what you have in place. Because if you've actually got documents that do everything you need them to do, we're going to tell you that. We're going to tell you, no, you don't need to make a change. Everything you've got, is sufficient. And so, yeah, we do want to look at your documents to help determine what needs to be done to get things set up. Good. So thank you. A very nice comment. Someone just said thank you in the chats. So what I'm going to do is just pick up a couple of questions that people asked about before the webinar and make sure that we've covered those off. So one of the questions was about the TFSA, and I think we've covered that tonight. Someone talked about living trusts and avoiding death taxes. So in Canada, what we have is not really a death tax, we have a probate tax. And so the probate tax is 1.4%, so it's not a really big number, and it applies only to assets that pass through a will. So this is something that it's, not joint assets that go automatically to somebody on survivorship, not, beneficiary designations like insurance or tax-free savings accounts, but it's an asset that's in the person's name, and we need to use the will to transfer it to somebody else, and we have to take that will through the court process. So when we put it into the court process, the court, one of the questions it asks is, what are the assets? And you have to disclose them and what the value is. And then before the court will approve the will, give you what's called the grant of probate, they say you must pay us 1.4% of what this value is. So on $1 million, it's $14,000. So it does add up. And because of that, some clients, if they have larger estates, I would say you've got to be kind of 2 million or more before you start thinking about this. We can actually create trusts while you're alive and take all of your assets out of your will and have it in a trust so that when you die, the trust just distributes the assets, not the will, and it avoids that 1.4%. But as I say, you've got to be kind of in the $2 million range where it's about $30,000 that you're trying to avoid before it makes sense to start thinking about those living trusts. So one other question, can an individual have more than one trust in their name? Yes, you can. So we were talking about that before. You just have to make sure that it makes sense because having multiple trusts means you're paying, multiple sets of costs when you do that. The next question was, I would like to know what I need to do first to start making to first start making a will. So I think that the first thing you would want to do is come and attend a webinar like this. Find out a little bit about what it means to make a will. Probably not a bad idea to, if you're going to engage a lawyer to talk to them, we send to our clients a questionnaire so that people can start kind of recording what their assets are and start thinking about, well, who would I want to be in charge? How do I want to divide things up? Once you've started getting some ideas about that together, that's the time to come and talk to a lawyer. Remember, you don't have to have all the answers. Part of my job is to help you get those answers. And helping you pick a trustee is often a really hard thing to do. And so you don't have to have the perfect answer, just have some ideas, and then we can sit down and figure out, what makes sense for you. So the next question is, any recommendations for wills for an individual with an RDSP? Is this necessary? Yeah, it's a really good idea to have. The RDSP, when a person passes away, their RDSP goes according to their estate. And so your will can help direct where that should go. So I think it's a great idea. For anyone that's got an RDSP, if they're able to make a will, it's a good idea to do it. So there was a question about the cost for will planning. We've talked about that. Please clarify how the specific trust money can be used and by who. So we talked a little bit about that. So once it's in the estate, in the trust, it's protected as an asset. But when you pay money out, you have to be careful that it doesn't go offside for the income tests. That's where you're going to do the disability related costs. So remember, we talked about things that promote independence. You always have to have a purpose for why you're spending that money. If you do, it'll be exempt and it'll not affect the person's eligibility benefits. And you can pay it directly to the person. You can pay it to third parties on their behalf. We sometimes pay landlords directly or pay school for tuition, buy trips, that kind of stuff. And then a question, can the parents be the trustees of a Henson trust? Well, I guess that's kind of a depends answer because the definition of a Henson trust is a discretionary trust that's typically created in a will. So if it's created in the will, typically the parents will have already passed away because it's their will. But you could set up a trust, an intervivalist trust that would be like a Henson trust, discretionary, and the parents could be in charge of that while they're alive. And then just one last question, it looks like. If your disabled loved one passes, should they have a will that their assets go to where they wish. Yeah, yeah, for sure. I mean, I really believe that, anybody that's got some assets and a disabled person who has an RDSP or has their own investments, they have something that they will want to express what their wishes are about where it should go. And because if you don't, then it's going to default back to those intestacy rules and be a little bit awkward. So if they can go and make a will and set out who they want to be in charge of it and where they want it to go, I think that's really empowering. And it's also, quite useful for managing those things. And sorry, another question has come in. Is it possible to make a will when there is not yet a decision about future living situation for your disabled son? Yeah, that's probably, one of the even more important reasons why you would make a will. Because if things are uncertain, the will allows you to decide who will make those decisions and how they will use the assets. So you don't have to have a perfect plan about what's going to happen yet. Part of our job is to set you up so that you've got the right things in place to do that. And then, if you take another couple of years before you come up with that plan, and then we come back and make some revisions, that's okay. We can always make adjustments, but you want to have something in place so that you know who's going to try to take up the mantle, I guess, and put a plan in place for you. And then another question was, are some people not allowed to make a will? So it's not so much not allowed to make a will, but do they have the appropriate decision-making ability to make a will? So we often call it capacity. And so capacity means, can I make decisions and fully understand the nature and the consequences of what I'm doing? So a will, excuse me, to be able to make a will, you need to understand a few things. So you need to know who your family are and who expects to benefit from you. You need to know what your assets are and what their value is and what they're worth. And then you also need to know what it means to make a will, that you're making a written document that will take effect when you die and describe what should happen to your assets. So if you can understand those three things, you can probably make a will. But if you can't, and sometimes the one about understanding money and its value is the hardest one, you might not be able to make a will. And then we would go back to those intestacy rules. So I think that covers, oh, one more question. With the trust, can I designate where my trust goes when my daughter passes? Yes, absolutely. So remember we were talking about you can't just name the trust for your daughter, you have to also name the ultimate beneficiaries. So in that case, you can pick when your daughter passes away, if she has children, would it go to them? If she doesn't have children, would it go to your other kids? Would it go to their grandkids? Would it go to a charity? You can pick all of that in the trust. And what's important is that doesn't depend on your daughter to make a will. Your trust deals with that. If she does or doesn't have a will, it doesn't matter. The trust sets it out. So you have some control over where that inheritance is going. Well, so lots of really, yeah, phew, I agree. Lots of really, really good questions tonight. That's fantastic. You folks are obviously thinking about these things. And so that's really encouraging. I learn a lot from the questions that are asked. And so what I would do is maybe just wrap it up this way. I would encourage you to explore these different resources. Think about what we've talked about tonight, what some of the questions are, continue to explore it. But at the same time, don't be paralyzed by trying to feel like you have to have the right answers before you take the next step. A lawyer who knows this information will be good at helping you work it through and understand what the specifics are that apply to you and will help you make decisions. So you might not know exactly who the trustee would be, and lots of my clients don't when they come in, but we help them walk through the questions to decide and make that decision about what it would be. So I'd encourage you to take that next step. And if you do, I think what you'll find, like a lot of my clients do, is it gives you a lot of peace of mind to know, well, at least I've got that in place. I know it might not be perfect. I might have to still do some stuff down the road and thinking of it, but at least I've got myself protected for that much of what I'm doing. So Julianne, I think I will wrap it up there. We're a little bit early tonight, but I think it's covered a lot of ground. And again, I really appreciate the invitation to be here and thank everyone for all their great questions.
Thank you so much, Geoffrey. This information can feel overwhelming, but sessions like this truly help families feel more confident and prepared when planning for the future of their loved ones with disability. We deeply appreciate your time and expertise. To everyone who joined us today, thank you for being here and for your thoughtful engagement. We know that conversation about will, trust, and estate planning can be emotional and complex, and we're grateful you chose to spend your time learning with us. If you would like to revisit any part of today's session, please remember that the recording will be emailed to you in the next few days. If you're interested in learning more about the Family Support Institute or connecting with other families, please visit our website at www.familysupportbc.com. All of our services are free and we are always here to support you. A reminder that we rely on your feedback to keep improving our sessions. A short survey will pop up when you exit Zoom. Please take a moment to fill it out. Your input is truly valued. On behalf of FSI, thank you again for sharing this space with us. Wishing you all a safe and peaceful rest of your day. Thank you so much, everyone.
Thanks, everyone.